Thank you, gentlemen. All right, so for the record, we're here on our the next case is WESTRA Construction versus Gator Boring, and as you indicated, there is a cross-appeal filed as well. All right, sir, you may proceed.
Thank you, and may it please the court. Good morning, Your Honors. With me is William McFetridge. My name is Jack Ryder. We're here on behalf of WESTRA. I will reserve 5 minutes for rebuttal, but I'd ask if at some point if I may switch to the cross-appeal side with the court's indulgence.
Absolutely.
But I'll start off, Your Honor, of course, with our primary, what we're seeking reversal of is the denial of the directed verdict with respect to the fraudulent claim of lien. Let me start off by addressing some of the procedural issues that have been raised. Yes, Your Honor.
Let me see if I could streamline all that for
Thank you,
because
Your
I've
Honor.
worked, even though we don't talk about the case ahead of time, I've worked with these judges before, and everybody knows the facts. As I understand with respect to your issue, and I actually pulled up this, there was actually an agreement as to what is going to be presented to the jury. In a nutshell, what boiled down to is the amount of the 200 and some thousand. The court has already granted and indicated that the lien in the 600,000 amount, that's not, but it's all that's going to go to trial is that amount. And if I could pull it, I could tell you exactly what it is. So we're dealing with that issue going to trial, and then you may proceed.
Yes, Your Honor, and I want to make sure that I'm honing in on what Your Honor wants to address.
Yeah.
Specifically, what we are referring to, what I'm referring to is it is our position that when there is a fraudulent lien claim, a fraudulent claim of lien, that constitutes an absolute defense to the ability for Gator to be pursuing its claim, and also it was raised both as an affirmative defense by WESTRA and as a claim in the sense that it was brought to basically moot out or eliminate the obligation here based on the improper claim of lien. I want to specifically talk about the affirmative defense component, Your Honor, because
when you're doing that, there is a case from our court indicating that with respect to whether a lien is fraudulent, it's a question of fact. So while you're addressing that, make sure you address that case as well.
Absolutely, Your Honor. I mean, and what makes it interesting is the case, at least one of the cases, was the Gator case that preceded this case. But this case is different, and the reason why a directed verdict was appropriate here is because when we talk about what constitutes a fraudulent claim of lien and why the lien here was fraudulent, using that terminology, such that it should have been eliminated and the lien claim was improper, and why it constitutes an appropriate affirmative defense is because here it is undisputed that Gator included within the claim of lien approximately $40,000 worth of costs for work that was not performed by Gator. Your Honor,
the concept of a fraudulent lien really connotes a willfulness, an inflated value that has no support for it. They were back charged for this, and they were back charged for the cleanup, for the frack outs. So what are they supposed to do, just eat it?
Your Honor, I respectfully disagree with one of the things you said, and then I'm going to answer right on point the question you asked about whether they should eat it. Let me start with why I respectfully disagree. The language of the statute, 713.31, is very clear. A fraudulent lien is defined in the disjunctive, using the or to separate the different types of fraudulent liens, where, quote, where the liener has willfully included a claim for work not performed or materials not furnished for the property upon which he or she seeks to impose a lien. That is the start and stopping point of the language of the statute, Your Honor.
You never perform a subcontractor's work, and that's in effect what these cleanup companies were. TICO hired them, as we know, because they were concerned about the environmental impacts of the frack out and the stuff being left around. So they hired them. So they're either TICO subcontractor or they're a forced subcontractor of Gator, but Gator gets charged for it.
But Your Honor, the bottom line is that Gator did not perform the service, and the language of the statute is unambiguous.
So let me ask you a question then. Anytime a contractor files a lien because they didn't get paid, they're not entitled to include the amounts of their subcontractors who did not get paid.
Your Honor, there is no support, there is no case that I'm aware of that would indicate that a subcontractor can impose a claim of lien for work not performed because there is the possibility that they might be subject to the cost later in the future. Under that scenario, Your Honor, and I'm going to answer the question you asked whether or not they were supposed to just eat it, using your words, they didn't pay it. They didn't perform the service.
That's tantamount to paying it.
But, Your Honor, the difference is, okay, as at the time it was performed by a different entity. So to suggest that because they are going to be back charged, that gives them the right to impose a claim of lien, suggests that they will be able to double recover. Because in other words, that means that they can foreclose the claim of lien, essentially seize the property, sell the property, in order to try and take advantage of obtaining money in advance because they're saying they're going to get back charged in the future. At the time they imposed the claim of lien, what we know, what is undisputed, what Ms. Lyons on behalf of GATOR admitted, was that GATOR did not perform this work and GATOR did not pay for the work. Now, if the fact that they are going to be back charged at some point and then be responsible for it, I would respectfully suggest, since that hadn't happened, that does not give them the right to impose a claim of lien, encumber the property, and then foreclose on that claim of lien when they haven't actually paid or provided the materials. That is not, with due respect, Your Honor, the plain meaning of the statute. And the statute, as framed...
Well, you and I won't agree on that,
well,
for sure.
Your Honor, again, I understand the court's point, but again, I think, with respect, there is no indication when you read the language of the statute that specifically says that a lien that's imposed for work not performed and money not paid, to suggest that the entity can then impose a claim of lien. That in and of itself, Your Honor, is in fact it's a willful imposition of a lien, and it was undisputed at the time that lien was imposed. Nothing had been performed by GATOR, and no money had been paid with respect to the xylem and Gaffin work. So I hear Your Honor's point with respect to what might seem equitable in the sense that there is this notion that they will ultimately be back charged for it, but that doesn't change the plain and clear language of the statute, Your Honor, which says that at the time it was...
That statute contemplates a completely bogus claim.
I respectfully disagree, Your Honor. I believe, Your Honor, I understand that this court has spoken with respect to the notion, and I know that we believe in this instance that there is a clear willful violation of the statute. Willful in the sense, twofold. The first willful violation, which makes it a fraudulent claim of lien, Your Honors, is the fact that GATOR knowingly and intentionally imposed a lien when they have acknowledged that they have not performed the work. That doesn't require fraudulent intent, Your Honor, because the statute doesn't require it.
Yeah, I looks to me like what they did was in good faith, because they know that they were stuck with it. And so it was part and parcel of their loss, which is why it was included.
Well, Your Honor, again, I understand, but when to say they performed in good faith, for example, in this court's decision, the Chumra decision, this court talked about what constitutes good faith. In that case, a contractor actually provided services. They did things to prepare the property in order to protect it from the elements. That was good faith, Your Honor. Here, GATOR was responsible for the loss in the first instance with the frack-out leaks. TICO and WESTRA had to go out and hire subcontractors to do the work in order to stop leakage and contamination. And ultimately, GATOR knowingly imposed a lien when they admitted that they did not perform the work. And I would respectfully submit that that is not good faith. However, I think the good faith context has to do with something that is if there's a disagreement about a cost, not a disagreement about whether work was done.
If they hadn't been back charged, I'd be with you 100%. But they got back charged. That makes it different.
Your Honor, again, I respectfully disagree, but I understand the point. The other point, though, yes, Your Honor.
Mr. Ryder, because along, I guess on that same point, but a question. If our court indicated in the past that whether or not a lien is fraudulent is left up to the trier of fact, it's a question of fact, and in our previous case we reversed the summary judgment saying it should go to the jury, why in your case a directed verdict is appropriate? Isn't that a question of fact that should be going to the jury? And in this case, the jury in their verdict form basically came to the conclusion that there was no bad faith, they checked mark, in fact, got the verdict form here somewhere, but
yes, Your Honor.
How do you reconcile
Understood.
that, Mr. Ryder?
I believe, Your Honor, it is very, very easy to reconcile. There is a difference between, and although we respectfully disagree in the sense with the decision, the prior decision, we don't disagree with the decision, but I think that was summary judgment. And this is a different context because the facts were more developed. The facts were completely developed through the trial. And what we have now, okay, at the close of this case, what was undisputed and what was established through the evidence that was presented was that GATOR imposed this lien improperly. And I'm not going to suggest, the concept of bad faith, I submit, only applies to a disagreement as to the amount, but does not apply when here has been established through the facts that the lien claim was imposed not just because of the discrepancy between the work performed when they were told under the contract. And Judge Morris, as you pointed out in the prior oral argument, GATOR knew what they were doing when they entered into this contract. They were told that they had to base their fixed price contract based upon the information available to them. Undisputed, as Your Honor pointed out during the prior argument, and that is undisputed. They had the information and GATOR went ahead. It's undisputed that they never examined the property, they didn't look at the property, they didn't hire their own geological surveyor or other engineer to examine the property. They went ahead, they bid like other bidders, and they entered into the contract with WESTRA. Once they got to that point, there are two things that happened here that make this a bad faith claim of lien. One was, notwithstanding the fact that there was no differing site condition clause in this contract, and they were told, GATOR was told in writing, they were not going to be paid for the fact that they believed that there was a difference in the work that they had to undertake. They were not going to be paid extra, and they forged forward and then imposed a claim of lien, notwithstanding the fact that there was no different site condition.
We got a lot of information on record that says that you and employees of TICO made all sorts of oral promises to them. As they continued forward, they're going to get taken care of.
Your Honor, the bottom line is that the written documentation in place and in writing, they were told, they being GATOR was told in writing twice, their request for an overcharge based upon the claim that there was a different site condition was rejected in writing.
There's also a lot of information in our record that suggests that WESTRA in particular withheld a lot of this key information from them about the existence of this rock, including but not limited to the TICO engineer's email that was forwarded and then redacted and passed on, information about the second report, things of that nature. I mean, there's a lot of that information that you guys kind of look like the bad guys in this somewhat.
Your Honor, there is absolutely no withholding of information here. First of all, this reference to an email, let me go back, and I'm going to start from the perspective of, as Your Honor pointed out previously, and I think absolutely correctly, GATOR was on notice that they had an obligation to do their own investigation. Let's talk about that email. That email involved an area of property 10 miles away, not even 1,000 feet away, 10 miles away, and that's undisputed. And I'll also point out this notion about the first and second report, completely misleading, Your Honors, for a number of reasons.
They were on notice, or GATOR should have done their own due diligence.
Absolutely.
There's no question about that.
That's right.
But
and I think it starts
you
and
all
stops there.
undertook to make some disclosures about what was there, but you didn't make full disclosure of everything you had.
Your Honor, I
kind of
respect...
told them some of the stuff, but not all of the stuff.
Your Honor, respectfully, I disagree based on the record, and here's why. This reference to a second report, WESTRA didn't even have the second report until discovery was ongoing in this case. It's undisputed that that second report that we've heard about in the prior case, and I'm trying not to filter it together, but that second report we heard about, that was never given to WESTRA. That was something that wasn't even created, the second report, until after GATOR signed the subcontract. And it wasn't even in the possession of WESTRA until discovery was ongoing in the litigation process. But more important, and I don't know, that may be the most important factor, but I also want to make clear, that second report, that talked about, and Judge Kuzam, as you pointed out, that second report and first report, they said the same things. They talked about limestone. Both talked about limestone. The second report involved a different location, the different side of the river. It wasn't what was under the river where the problem was encountered, and it involved a different geological issue. It involved, the reports talked about limestone, not quartz, not chert. And the Brealey report that has been referenced by GATOR in their moving papers, and I'm sure they'll talk about it today. The Brealey report was about quartz. not about limestone, and there's nothing in either the first or second report that talked about chert or quartz. I don't know, I'm using them similarly. I don't know if they're exactly synonymous, but chert is the item, the mineralogical problem that they ran into, GATOR, when they were drilling, not limestone. There's no information. Yes, Your Honor.
At what point did WESTRA know about the subsequent core borings?
The subsequent core borings, certainly not at the time of the entry into the subcontract with GATOR, Your Honor.
But they'd been done by then. So everybody says they didn't know about them, but they were done by. Everybody agrees they were done in the late spring, early summer of 2013, but everybody claims they didn't have them.
Your Honor, I'm not sure.
I'm sure somebody paid the bill for the people that did the core boards.
Well, there may have been core boards by TICO, Your Honor, in the sense that as the property owner, they were the ones who were in control of the property. But WESTRA, from its perspective, as the primary contractor going out to hire subcontractors, it did not have access to the property at the time it entered into the subcontract with GATOR. And it's undisputed that, like all the bidders, WESTRA couldn't treat GATOR any better than the other bidders, who in the bidding documents were told that they had to undertake their own investigation. And Ms. Lyons, on behalf of GATOR, admitted that GATOR did nothing.
And I want you to address some of your cross appeal, if you'd like. I know you've interwoven both of them, but just to let you know, because you're 13 minutes into your argument right now, so I want to be able to alert you. And I realize that Judge Morse peppered you, but at least. All right.
I welcome the questions, Your Honor. It gives me a chance to enlighten the court a little bit, to talk.
Tell me what I think, give me a chance to respond.
Well, I appreciate that, Your Honor, and I still want to make sure that I've addressed your questions, even if we don't particularly agree on some of it. But on the cross appeal, and again, we've sort of filtered into a little bit here, Your Honors, but to be clear, there is nothing that GATOR did that could have misled, that WESTRA did that would have misled GATOR here for a number of reasons. I started from the same place I was at a moment ago, and that is that GATOR had an independent obligation to undertake its own investigation, and Ms. Lyons admitted that they did nothing. They did not investigate, they did not ask for additional borings, they did not ask for whether or not they could gain access to the property. They simply bid and accepted the opportunity to enter into a contract. And the law does not allow a party to rewrite a contract after the fact because they realized that they bid off more than they could chew. And that's what happened here. In the Brealey report talks about the fact that the existence of hard material, and Judge Morris, you pointed out, everybody knows under Florida soil, especially people who are in the business of drilling, they know that they're going to likely encounter some bumps and rocks in the road. I mean, typically, here we have a very, very specific situation, and at the end of the day here, GATOR could have undertaken, if the Brealey report would have made a difference, they could have done that before they made this bid. They elected not to. So there's there are multiple reasons here why there's no any kind of fraud or any kind of misrepresentation by WESTRA, starting from the place that GATOR had an independent obligation to undertake its due diligence and did nothing, number one. Number two, WESTRA did not have this famed second report we've heard so much about until the litigation was undergoing. And number three, the second report had nothing different than the first report because it talked about limestone, which is the same thing that was in the first report, and it wasn't the problem that GATOR encountered while they were drilling. I know I must be close to my time, so I'd like to stop here and save the rest of my time for rebuttal.
Very good.
Thank you so much.
We have about 4 minutes left. All
Thank
right?
you.
Thank you, sir.
Thank you, Your Honor. Robert Emanuel here again for GATOR boring. I'll first address the fraudulent lien issue and then move on to the cross appeal issue. I think what's important with regard to the fraudulent lien issue is, first of all, as Your Honor's indicated, this court has previously determined that's an issue of fact to be determined by the trier of fact. Here, the jury had the benefit of a 5-day jury trial and the opportunity to judge the credibility of everyone, including Ms. Lyons, the parties that testified for WESTRA, and TICO. As Your Honor indicates, the verdict form was very clear and basically tracked the statute and allowed the jury to make a determination under any of the 3 subcategories if the jury believed the lien was fraudulent. And the jury said, no, it wasn't fraudulent. I think it's also important that the trial judge, in reviewing the motion for new trial or motion for a directed verdict post-trial had the benefit of seeing all the evidence, hearing all the testimony, judging the credibility of everyone, and the trial judge, the person in the best situation to judge the collective of everything, decided that the motions should be denied. And here, the standard of review is a motion for directed verdict should only be granted if no reasonable jury could render the verdict that was rendered. And here the record has substantial evidence to support the jury's verdict. Ms. Lyon's testimony, the fact that WESTRA recommended that GATOR include those monies paid to the third parties in their claim to the owner, the fact that GATOR was back charged for that work. And so when counsel says GATOR never paid for the work, as soon as GATOR was back charged, GATOR had in effect paid for the work. The back charge constitutes payment. Additionally, it's undisputed that GATOR sought advice from counsel who prepared the claim of lien, a Florida lawyer who is also a board-certified construction lawyer, who advised GATOR and prepared the claim of lien for GATOR. So I think all those are evidence of good faith. Ms. Lyons testified that she prepared the claim of lien, provided the information to counsel based upon what she believed in good faith GATOR was entitled to after she read the contract and discussed it with her counsel. So for various reasons, we think that the trial court was correct with regard to the fraudulent lien, denial of the motion for new trial and directed verdict, and the jury verdict is clearly supported by the record. With reference to the cross appeal, I think what's important is to point out the difference between the information on which GATOR submitted its initial bid and what changed between that time and when GATOR was asked more than a year after WESTRA had entered into the contract with TICO to submit a second bid. And it's undisputed GATOR asked WESTRA at that time, has anything changed? Is any of the information different? And WESTRA replied, no, everything's the same. We know, Judge Morris, as you indicated, there was this email chain that emanated from TICO's engineer that went to WESTRA approximately a week before GATOR entered into subcontract with WESTRA that says, hey, warn the boring subcontractor that they're going to encounter rock. And it's very clear that WESTRA's representative redacted that portion of the email and then sent the rest of it on to GATOR.
We've kind of covered the fraud part of this pretty extensively, but what we haven't spent as much time on is on the contract part of this, so I kind of don't want our time to run out without doing that. Because if I understand your position is that you've taken the position that section 3.12 of the contract has a change site condition clause, and that would allow you to ask for more money because you encountered these problems. Is that a fair statement?
That is a fair statement, Your Honor.
Okay, so 3.12C2 says to get paid for an obstruction removal of this nature, the subcontractor must get written approval by the owner. You agree with that? That's what that clause says. 3.12C2 says to get paid for obstruction removal, which is what this was, that the subcontractor must get written approval by the owner.
That is correct what it says, Your Honor.
Did you do that?
Your Honor, we sought that approval in the meetings that have been discussed, and we understood the discussion in those meetings that TICO authorized us to proceed with that work, directed us to...
But you never got the signed written authorization?
That is correct, Your Honor, but I think the case law is very clear. The fact that there is not a signed change order does not preclude a subcontractor from pursuing a claim, because most subcontracts and contracts have a provision where the owner, or in this case the general, can direct the subcontractor to do additional work under what's called a CCD, and then we'll figure out the amount later.
This contract said you got to get a signed approval from the owner if you're going to expect to get paid for removing the obstruction. And if you didn't get it, you got an uphill battle here, even in the face of all this oral conversation, would indicate some sort of working relationship,
Well,
because,
John, I understand, but it puts Gator in a catch-22. We were acting in good faith and proceeded to do the work. We had meetings where we understood the discussion to be, do the work and keep track of your time, and we'll make sure you get paid. And we, in reliance upon that, proceeded.
but if you don't have what the contract says you gotta have, all that conversation's just friendly chit-chat, isn't it?
I disagree, Your Honor. I mean, the case law is clear. You and I can have a contract that requires written change orders. But if we agree and proceed with verbal agreements for you to direct me to do extra work and agree to pay for it, that's binding. Whether it's a verbal agreement to the contract, whether it's a separate quantum meruit approach, under several theories that can happen. And the case law is legion, where you have a contract that says, you know, an integration clause and a written change order clause, but the parties, for whatever reason, ignore it in a particular circumstance.
It's really
and
hard for me
proceed.
to understand that sophisticated parties like this, who know how to find lawyers, would go forward in the face of this big contract and this significant problem with a provision that says you got to get signed by the owner and just say, okay, we're going to trust everybody here. It's just, it's a hard sell.
Well, Your Honor, I understand. I've been doing this construction law stuff 40 years, and clients routinely do that in the field because they're acting in good faith, and the emphasis is expediting the work, keeping the job on schedule, getting the work performed, and they trust each other that they're going to be treated fairly. And I see that all the time, where the parties ignore the written, you've got to do this, you got to have this signed, because out in the field, the goal is getting the work done and trusting that you'll be treated fairly. And that's what Gator did in the dealings with WESTRA and the dealings with TICO in those meetings, and proceeding with the work.
I practiced law a long time before I became a judge and did this kind of work. I don't think I ever saw anybody pay on an oral commitment, ever, one time.
Your Honor,
You didn't have the paperwork, you weren't getting.
well, Your Honor, again, it becomes a proof thing, but I can say in more recent times with emails and stuff, sometimes it's easier to establish that communication. But I agree with you. Do clients proceed at risk of being able to prove that and establish that? Yes, but I think that's a matter of proof in this case, not something to be decided on summary judgment when you're talking about whether there were discussions, whether there was a promise to pay, whether there was a representation that was relied upon in the work performed. Clearly, meetings were held. My client has testified of what those discussions were. It's undisputed my client in good faith proceeded with the work, got the work done, didn't try to hold the job hostage, didn't say, you got to give me something in writing before I proceed. My client proceeded and got the work for the benefit of the owner, which is what was the right thing to do. In retrospect, if I had been involved with the documentation had been somewhat different, yes, I think it would. But the important thing is what's fair, what's handled in good faith. And I think here we're on a summary judgment that was granted as to these types of claims, and I think it was not proper for those claims to be determined on summary judgment. I think that this court, we would request reverse the summary judgment as to those matters so the record can be fully developed and the issues determined at trial. Thank you very much.
Thank you, sir. Sir, you have about 4 minutes.
Thank you, Your Honor.
sir.
Thank you. One thing I did want to mention, going back to the notion of a back charge, because Judge Morris, I still think maybe I can convince you. With respect to the issue of the back charge, it would be one thing for the subcontractors, for Gator, to come and sue for some monies back if they were in fact back charged. But what the problem now here is, Your Honor, and with respect to, and why the concept of the back charge doesn't change or shouldn't change the analysis, is because as it is now, WESTRA is being asked to pay twice, because they've already paid for the amounts of monies necessary for Xylem and Gaffin to do the work that was required at the time, and they're being forced to pay on this claim of lien, which includes the same amounts of monies. So what ends up happening is it's really being double charged, it being WESTRA. And from a perspective of equity and, as I said, what I believe to be...
The jury deducted that amount. Would you agree?
Understood, Your Honor, but I don't believe that that goes to the issue of, under the plain language of the statute, whether the claim of lien is valid and enforceable. And that's the issue. That's our issue, Your Honor.
You're taking the position very literally that the statute says that you have to do the work yourself. So you disagree with Mr. Mann when he says a back charge, and I quoted that, constitute payment. You disagree with that statement?
I do disagree with that, Your Honor. And to answer your question, do I believe the statute should be read and applied literally? I believe that is what the law requires. I believe, with respect to the court, that the court's role is to apply the language of clear and unambiguous statutes as written, and not to rewrite them in a way based upon claims of what might be or might seem more equitable. I would submit, even under principles of equity, not imposing the statute as written actually results in inequity to WESTRA. But
because the statute doesn't say for work performed. It doesn't. So the question, it begs the question, in this case, ultimately the work was performed, right?
That's right, Your Honor, but and I look at the Chumra case, and I don't know if I'm saying it correctly, but in that case, this court talked about the fact that their value was presented by the contractor imposing the lien. It wasn't by some third party, and then the contractor said, well, somebody did the work, so if someone did the work, I might as well take value of that and put a lien on the property. And that's what's really happened here. GATOR did not provide those services. They did not provide the work, and they did not pay for it. Notwithstanding the idea of a back charge, they didn't pay for it at the time, and at this point, it's really a double charge to WESTRA, and that's not fair. And that is what happens if we don't apply the statute literally. With respect to the issues on cross-appeal, unless there's any other questions about that, Ms. Lyons, who testified on behalf of GATOR, she testified, and this is at the record 1123, in comparing the two reports, this first and second report, because I want there to be no doubt in this court's mind that there was nothing withheld by WESTRA, nothing. Ms. Lyons admitted that the bores conducted and referenced in the second report were outside the footprint of the Alfire River. She admitted that there were no borings within the horizontal footprint, the footprint of the horizontal directional drilling. That's at 1124. At 1124, Ms. Lyons admitted that no documentation suggested that anyone knew about the chert under the river. At 1126, the chert that was encountered in test bore 230, which Your Honor asked about, was 1,000 feet away. Several football fields, Your Honor, as you pointed out before. Record 1142, Ms. Lyons admitted that the reports referred to limestone, not chert, the material that the drill ran into that caused the problem that's being complained about. And finally, the record 1142, Ms. Lyons admitted that she could not identify any materials in the second report that were different from the first report. So I wanted it to be very clear. There was nothing here that WESTRA withheld or information that was withheld that in any way acted as an inducement to enter into a contract, particularly when GATOR bid on this contract just like everybody else based on the information available. Judge Morris, you asked about the differing sites conditions clause.
Because you ran out of time, but very quickly.
I'm going to wrap up with this. As Your Honor pointed out, they had to get it in writing. They did not get in writing. In fact, what they got in writing was no, this was not a differing site condition clause, and they were not going to be compensated for it. And finally, there is no differing site conditions clause here because that required the removal of a man-made object, and that's not what was here. So I would ask that the court reverse as to the directed verdict issue and remand for entry of judgment in WESTRA's favor on that claim, and affirm as to the summary judgment with respect to the cross appeal. And thank you, Your Honor, for allowing me to go over a few moments. I appreciate it.
And thank you all, really.